a high court in the federal court said, hey, high court in the state court, can you please give us some direction?
Exactly.
The Weekly Friedman, your source for the most essential information in the default industry. With your host, Adam Friedman.
On this episode of the Weekly Friedman, we're diving into the quiet title action, Article 13 LLC versus LaSalle Bank. In this potentially industry-shaping case, the U.S. Court of Appeals for the Second Circuit once again requested that the New York Court of Appeals weigh in on the Foreclosure Abuse Prevention Act retroactively, but in an even broader manner than before. Joining me to break it all down is Friedman Vartolo, appellate attorney, Steve Vargas, who's been following this case closely and has some great insight into what it could mean for lenders, servicers, and property owners. Let's jump in, though, to the case now. So we understand the arguments being made, right? So what does the court do?
The court ultimately applied FAPA retroactively, the CPLR 213-4B, the estoppel section, and said LaSalle Bank cannot argue that its predecessor lacked standing to accelerate via commencement of the first foreclosure action. So the federal district court said, based on the retroactive application of this FAPA amendment, the 2007 acceleration was valid and this mortgage is time barred. So what did LaSalle do? They took the appeal to the Second Circuit Court of Appeals. Now in the East Fork Funding versus U.S. Bank, Weekly Friedman, in October, we had a two-piece series on this. The federal appellate court noted that the state's highest appellate court had not weighed in on FAPA at all. And the federal appellate court said the state's lower level appellate court, they've issued rulings on FAPA, but they haven't given us enough reasoning where we want to just follow their reasoning without asking the Court of Appeals to get in. So they're saying until the Court of Appeals weighs in, we're going to refrain from deciding. So in that case, the Second Circuit asked the Court of Appeals, please weigh in on whether and to what extent FAPA applies retroactively.
We're saying a high court in the federal court said, hey, high court in the state court, can you please give us some direction?
Exactly. Most importantly, I think as far as when the federal court's concerned, it's interpretation of a state law. They're saying the state Court of Appeals, the high appeals court, is best equipped to decide an issue of how to interpret state law based on the way statutes are interpreted in the state, based on potential policy concerns, saying we really would like you to decide this for us because you're best equipped to decide how laws from your legislature and your governor should be interpreted.
And to be clear, what they're not saying is decide my actual case.
They're not. They're not.
They're saying interpret this law. Give me a full understanding of this law.
Exactly.
So I could take that. And then when someone brings a federal case that's revolving around the state court law, I know what to do.
Precisely. And that's exactly what they did here. In this case, and this is the pivotal scope, so they asked the State Court of Appeals, they issued a quote certified question, which is the federal court scoping a question for the state court to respond to. Whether and to what extent does CPLR 213-4B apply to foreclosure actions commenced before the statute's December 30th, 2022 enactment? That's question number one. So it's virtually identical to what was certified in the other federal appellate case involving FAPA amendments. However, I think maybe to entice the State Court of Appeals, the high appellate court, to take the certification, the second question they certified was whether FAPA's retroactive application violates the right to substantive and procedural due process under New York State Constitution, Article 1, Section 6. What they did also, though, of course, as a federal appellate court, they reserved the issue of the question of whether any sort of federal constitutional violation would arise from the retroactive application of a FAPA amendment. The first time, the State Court of Appeals says, no, we're going to decline to answer this question, essentially deferring back to the Federal Appeals Court to do what it sees appropriate. So the Federal Appeals Court recognized this here in a footnote and said, we know you didn't take the case the first time. We think these facts are more appropriate for you to decide. We're also going to say, we need you to talk about the New York State Constitution. We don't want to get into that. We will address the due process clause of the federal Constitution, as is our prerogative, but we want you to address the state constitution because after all, you're the high appeals court of your state. You are best equipped to answer questions about Article 1 of your state constitution.
Why do you think the state court declined to make the decision the first time?
I think there was a particular factual nuance to the East Fork case where you wouldn't have to address either interpretation of the statute or constitutional issues. You can just apply, in that case, I think you could apply the res judicata or collateral estoppel doctrine, a common law doctrine, rather than have to interpret a statute. Just say, under these circumstances, res judicata applied, and therefore we don't have to get into any sort of interpretation. That doctrine overruled any sort of FAPA interpretation issues. There was a discussion in that case from at least one judge specifically saying, we may not need to get into FAPA at all. We may just be able to apply a common law doctrine and address the case on the merits that way. It's the most obvious explanation The other explanation would simply be that the Court of Appeals didn't want to get into any sort of sparring with the legislature, so to speak, where they may say the legislature passed the statute. The statute was initially created to overrule Court of Appeals precedent in the Freedom Mortgage versus Engel case about deceleration. It's not an issue we want to weigh in on. We'll essentially defer to the legislature and not touch the legal challenges to it. And if the Federal Appeals Court elects to do so, as they may be forced to, that's their decision. We'll address it if we have to, but we'd rather not address it, at least under those facts.
The state court is the highest court for the state. You would think that when the federal court says, this is really your call, we want to hear what you have to say, they would say, thank you for respecting me. You're right. This should be our determination, our decision. We're going to jump in here.
I agree. And in the foreclosure context, in the last 10 years or so, the Court of Appeals precedent has been very valuable. It started with the Aurora versus Taylor case in 2015 about standing, and then with decisions about the statute of limitations, the 90-day letter. And actually, there was a one certification, if you go back to 2020, the circuit court certified an issue about the 90-day letter and the proof of filing statement. And there was actually a certification from the Second Circuit to the Court of Appeals asking different issues about the 90-day letter, and the Court of Appeals accepted certification. So this is a situation where the Court of Appeals wasn't able to get the certified question accepted. The first time around, it did.
How does this certified question process work? Who could submit a certified question?
The Federal Appeals Court, so the Circuit Court, certifies the question over to the State Court of Appeals. There's a federal statute, and the New York Court of Appeals has a specific rule about it. They say, in a situation where there's a very important question of state law that we'd like the State High Appeals Court, it can only be certified to the State High Appeals Court. The Circuit Court cannot say to the Second Department, for example, we'd like you to answer this. It's only to the state's highest appeals court saying, you're the law of the state, you're the law of the land there. On an issue of interpreting state law, we need your opinion on this. And that's what the end result is. It's an opinion from the State Court of Appeals. So if this were accepted, what do you get? You get an opinion saying how the statute should be interpreted, applied to this case.
Could another state submit this?
So federal appellate courts can certify to any of the states. So like it could be, let's say whatever federal appellate court governs Florida, can certify to the Florida, whoever it is, whoever the high court in Florida is, Supreme Court.
All right, so Steve, so what's going to happen next?
Well, this question was certified last week. So last week, the Article 13 order came out from the Circuit Court, certifying the question to the Court of Appeals. I would expect within roughly 3 weeks, we'll get some sort of either acceptance or declination from the Court of Appeals. So in the East Fork case, that was about the window. It was roughly a 20-day window from when the Circuit Court certified the question, asked, please let us know whether you'll accept or decline. About 3 weeks later, the Court of Appeals declined. So I would say here, we're talking about, roughly 3 weeks from the end of March. So we're talking third week of April, roughly, for the State Court of Appeals to either accept or decline. If they decline, these issues that are sent back to the federal court to just decide the case. It's on its own. Whatever it chooses to do with respect to constitutional issues, statutory interpretation, that's what it's entirely in their discretion as to how to apply the law and whether it's constitutional or not. If the state court accepts the certified question, this case essentially is stayed. The federal court just stops the case. The State Court of Appeals issues a briefing schedule for the parties to brief the issues, and then ultimately hears argument and decides how FAPA should be interpreted and whether the state constitution is violated by the retroactivity clause in connection with this statutory amendment. So if the court were to accept, we could be talking about State Court of Appeals resolving these issues as far as the extent of retroactivity and the constitutionality under the state constitution, maybe spring of 2026. I guess potentially a little sooner just due to the gravity of the situation. If they decline it, then it's the second time they would decline certification. And I assume at that point, the Circuit Court would simply go about deciding the East Fork case and the Article 13 case. Because in my opinion, the Circuit Court may be waiting to decide East Fork. This could have industry-wide or change the scope of the statute of limitations litigation. The reason that's true is because if the Court of Appeals issues an opinion on this case, not only do we get does FAPA apply retroactively, we get the extent to which it applies retroactively, and we get to whether it violates the state constitution. And then the federal appellate court's bound by that. The state courts are all bound by that. The federal constitutional question is still outstanding, but if the state court says it's constitutional, my guess would be that the federal appellate court would rule along those lines and say, we'll also uphold the constitutionality of it. So it's in the Court of Appeals' hands. If they want to decide it, they'll have the opportunity to do so because the certified question, even broader than last time, is saying, please take the case. Please let us know. Please let every litigant in the state know how FAPA should be applied.
This is a fascinating topic.
It is.
And this is one of the best topics we've covered.
We'll be monitoring it.
I appreciate all the insight. I'm sure you'll be back soon.
Yeah, thank you for giving us the time to discuss this.
Thanks for joining Stephen Vargas and I on the Weekly Friedman, your source for the most essential information in the default